Well, this is the point at which Brian Cade will fill in the gaps and give you some more information about the open meeting law and what it requires. It's funny, I was thinking about this, the scene and the commissioners in the cafe conducting business. This was an issue that came up this year in regard to our redistricting commission, which I covered. We had two different redistricting commissions, if you remember. These are bipartisan citizen commissions. And the first commission consulted with Brian. They wanted to be very careful not to violate the open meeting law, so they never went to lunch together. The only problem was they also really kind of started to not like each other and not talk at all, but they did not violate the open meeting law by going to lunch together and conducting business. Now the second commission decided that they were going to go to lunch together, but they also consulted with Brian and said, we don't want to violate the open meeting law, we're not going to talk business, we'll just talk about our kids. And in fact, they got together for lunch and they talked about their kids. A reporter, Dan Poppy, even sat in on one of those lunches and reported, yep, they were talking about their kids. As a result, they all became really good friends, having spent all that time talking about their kids, and they very quickly reached a plan. Interesting. But they didn't violate the open meeting law. Well, I'm very pleased to introduce Brian Cade, who received his Bachelor of Arts degree in History and Political Science from the University of Idaho. He earned his law degree from the Northwestern School of Law at Lewis and Clark College in Portland, Oregon. Brian serves as legal counsel to the Secretary of State, the Legislature, and the State Treasurer's Office. He acts as a liaison between the Attorney General and local, state, and federal governments, and he handles all amicus requests. Brian and his wife Emily have been married for 9 years and have 2 children. He's an avid runner, having completed the Race to Roby Creek Half Marathon 4 times and the Hood to Coast Relay 5 times. He is also a 4.0 level USTA tennis player. Brian Cade.
Thank you, and I can disclose that this is my favorite stop in the whole trip. There's nowhere I enjoy coming to more than anything than Moscow. So
nice talk.
Well, also, you know what? I'm going to give you the full 100% honest presentation tonight. So the past 2 nights, this has been the second thing I most want to do with my time. Last night, it's easily defensible, my daughter's school program, her Christmas program. So I really wanted to be at that as opposed to being in Coeur d'Alene. Not that I don't love my job. Tonight,
good thing, right?
Thank you. And tonight, you know, I would love to be over at the campus watching that basketball game. And I think it's just, I miss Moscow. It's a great town. It's a great place. So thanks for having us up here. We're going to talk about the open meeting law. You have all gotten the brand new manuals. They're hot off the presses. One of the things that we've done with these manuals is we've actually reformatted them. In the past, when you opened up the manual, it was all law, and then the questions, we were sitting around thinking, well, generally people pick up the manual because they have a question, and so why don't we set it up so that they can get their question answered and then look at the law as they need to. And so we've reformatted it that way. We've regrouped some of the topic areas so that I think they're easier to find. As you go through it, if you find that you don't like the new format or you've got suggestions, feel free to email me. It's a work in progress, and we want to get it as effective as possible. So this is the preamble to the open meeting law, and it's very simple. Policy of the state that the formation of public policy is public business and shall not be conducted in secret. And so this is the overarching theme of the entire open meeting law manual. Open meeting law. This is not a novel concept. One of the things that's worth pointing out is that when the United States adopted their Constitution, how was the Constitution drafted? Does anybody remember?
Ours? Idaho's or U.S.?
U.S.
Hot summer.
What was the first thing that they did when they sat down to hammer out the new Constitution?
Close the meeting.
Close the meeting. They adopted a secrecy resolution. And Thomas Jefferson heard about this. He wasn't at the Constitutional Convention because he was where? Anybody remember? France. He was a huge tennis fan, and he was over there for the French Open. Another very little known historical fact. But anyway, he was over there. When he had heard about it, he was upset. He was very upset, and his statement at that time was, only the innocence of their intentions can forgive their ignorance of the value of public input. And so this notion of openness within government has been a partner with the creation of our government. And it's resonated, and it's ebbed and flowed throughout our history over time. And so Idaho has this strong policy. And so with this policy, I'm going to tell you a couple of things. Number one, the law is not perfect. If you want to find a loophole and outthink the law, you absolutely can. But if that's your purpose, if that's your approach, then you've already failed. Because the policy, the goal, is openness. And so I think that the real thing here is that you've got an imperfect law, but you're also applying it within a public service position. And so when you act as a government entity or government representative, you act within the public interest. And so the overarching public interest is this sense of openness. And so anytime you have a question with the open meeting law, and it's in our manual, if you have a question, resolve all doubts in favor of openness. And so as we go through this, I think it's important to remember that. The other thing that I will tell you about the open meeting law, we get this question quite a bit, is that the open meeting law guarantees you the right to observe your government in action. It does not guarantee you the right to participate. And so the open meeting law is your ticket to the meeting, but you don't get a spot on the stage. And so the entity, when they conduct their meeting, if they have an open forum, yes, you absolutely can participate in that. But if they have a meeting where they say we're not going to take any public testimony, that's their prerogative. Now, there are some political choices there, but it's not a legal issue. As we go through this, I've divided it up into 5 sections. We're going to do definitions, notice and agenda, conduct of the meeting, executive sessions, and enforcement. I guarantee you that if you pay attention to the first 4, you won't have to worry about the enforcement component. And then, on top of that, we're not done yet. Even if you make a mistake under the enforcement prong, we've now added a provision within the meeting that no one should ever get in trouble under the open meeting law, because you now have the ability under the law to fix any mistake that you make. Oh, of course. Okay, we're back on. The first thing I have to tell you is that since we're dealing with statutes here, there are some rules with statutory construction. And probably the most important thing is that if the legislature takes a word and defines it, that's the definition. And so if they say, if it quacks, waddles, and swims, it's a dog, for our purposes, it's a dog. And that's one of the things that you have to always keep in mind, is that sometimes you will run across a definition within a statute that doesn't make any sense. The problem is we have to deal with it. Idaho is actually notorious because we have a lot of statutes that define something one way in one part of the code, and then you flip about 30 pages back in the code and it's defined completely different. I refer to that as job security. But it can be a little frustrating for folks as they go through that. But keep that in mind. And so if you read something and you're thinking, that isn't the definition I remember from school, it doesn't matter. If the code has defined it, that's the definition. So we start out with a decision. And a decision is any determination, action, vote, final resolution on a motion, proposal, resolution, order of a governing body at any meeting where a quorum is present. And so the big 3 there are a final decision of any type with a quorum of a governing body. So that's your 1, 2, 3 out of that definition. That includes just about everything. What's not included are ministerial or administrative decisions. And I call this the big decision, little decision rule. And so if your big decision is, we're going to paint the barn red, you're good. Now, if you get into a little tiff and you can't decide if you want to use Valspar or Behr or Sherwin-Williams paint, you don't have to have another meeting for that, because you've already made the big decision, we're going to paint the barn red. Now it's time to get the paint and get it painted. Does that make sense? And so that gives you an idea of how you've got the big decision, but then the ministerial or administrative decisions, you're okay. Otherwise, you'd be always in meetings. I will tell you that one of the ironies of the open meeting law is that if you were to try to follow it to a T, you probably could never even schedule a meeting, because you could never get folks together to get the decision made on when you're going to have the meeting. And so a little common sense and reasonableness here goes a long way as well. Deliberation is the receipt or exchange of information relating to a decision, but does not include informal or impromptu discussions of a general nature. And this is, so when you have the decision, that seems kind of nice and narrow, but when you add in this deliberation, that really broadens the scope of the law, because now all of the steps that lead up to that final decision require an open meeting. Within this, it's important to focus on this impromptu discussions of a general nature, because as we've alluded to, we consistently get questions about, can we go to lunch together? Can we ride to a funeral together? Can we all show up at the same holiday party at the same time? And the answer to that question is absolutely. But I'm going to give you a little bit of caution. First thing I'm going to tell you is, as an attorney, whenever I show up at a social event, I, for whatever reason, seem to always migrate to other attorneys. And I think it's because, at the end of the day, we're the only folks that can stand one another. And every time I'm in that situation, the conversation follows a very predictable track. We talk for about 3 or 4 minutes about how are things going? Oh, they're busy. How are your kids? Kids are great. Any vacations? Yeah, we went to Disneyland. And then boom, we're kind of out of stuff. And so what's our commonality as attorneys? The law. And so we always start talking about the law. In some case, some lawyer did something crazy. Whatever it is, we always wind up back at the law. And so when you're a member of a governmental entity and you're going out to lunch, always be aware of what your commonality is. Because if your commonality is the fact that you all sit on the city council together, what's your natural migrating point when you hit that awkward pause? Work. What you have in common. And so be aware of that. And so as a person, you have to individually say, if I get to that awkward pause, am I going to be able to not talk about work? And if your answer to that is, no, I can't, then you need to rethink whether you should go to lunch and put yourself in those situations, because you're putting yourself in what I call tempting situations. The other thing to be aware of with that is perceptions. Idaho is a notoriously small state. I would not be surprised if somewhere out in town there's already a list of who's here and who you're sitting next to within this event. It's just the way that this state works. And so you have to always be aware of that if you show up at the cafe and have breakfast with the same 3 people every morning, everybody knows it. And so if that one day that you usually have a meeting that lasts an hour, you show up and your meeting takes 10 minutes and there's no discussion, why is that? Oh, well, they decided it at breakfast this morning. And so be aware of that perception as well, because it's a small state. So the answer to that is, yes, you can absolutely go to lunch, you can travel across town, you can show up at parties together, but be aware of what you're doing as you do it. Public agency. This is any state, board, commission. I'll cut to the chase here. There's not a lot that isn't included in public agency under this act. The most important thing with this definition is the part that says any sub-agency of a public agency created by or pursuant to statute, ordinance, or other legislative act. And so the real key here is that we run into folks all the time that want to get around the open meeting law by saying, oh, well, we didn't actually do an ordinance to create the subcommittee, or we had the mayor appoint the subcommittee. There's all sorts of variations that you can get into for creating the subcommittee to avoid application of the act. But at the end of the day, if your subcommittee or sub-agency, whatever you've created, is coming back to the main board with a recommendation for some sort of decision, my recommendation to you is always follow the open meeting law. It's 100 less headaches. And the other thing is that I will give you the $100 secret to the open meeting law. If you run all of your meetings open, people are just going to lose interest. And I think that, I think that the thing that people generally don't understand is that when you're meeting in secret, they can speculate, and so it's really, really exciting stuff. But when you really get into government, unless you're really into government, it's pretty dang boring. I mean, there's a lot, but it's necessary. I mean, don't get me wrong. And so, but the way to pique interest in anything is to say we're having a secret meeting. Because that fuels speculation, because you can make up whatever you want about what went on in that meeting. And so my recommendation is you can defeat all of that, particularly with things like subcommittees, by just saying, sure, come on in. And again, remember, even on a subcommittee, they have the right to observe, but not participate. Governing body is any public agency, which if you remember our last decision is pretty much everything, 2 or more members with the authority to make decisions or recommendations to a public agency regarding any matter. That's why the anchor in that last slide when I talked about subcommittees is the recommendation. So if you're making a recommendation that's going to result in a final decision, again, this is kind of a broadening portion of the law. And then a meeting is the convening of a governing body to make a decision or to deliberate. Or to deliberate is that broadening phrase within this provision. Toward a decision on any matter. In a regular meeting and a special meeting, very simply a regular meeting is a meeting that you have to have by law or rule. So if the code says you shall meet, that's your regular meeting. And then a special meeting is any meeting that occurs outside of that confine. Seems finicky. Gotta have the right angle, I guess. Up there? Okay. All right. Regular meetings. You have to have at least 5 calendar day notice of your meeting and then a 48-hour agenda notice. The exception to this is if you're an entity that meets regularly, like throughout the year. You can post a schedule of all your meetings for the year. And so say you meet the 2nd Tuesday of every month. You post that notice of the 2nd Tuesday of every month in January, and then you just have to comply with the 48-hour agenda notice. When you post your notice, it has to be at your principal place of business, or if you don't have an office, which there are some entities out there that don't have offices, where you're holding your meeting. We get questions all the time. Can we post our notice on the internet? Absolutely, provided you've met the statutory requirement, which is at your place of business. Anything above and beyond that is great. It's encouraged. It's probably helpful to you. You know, nowadays, I actually sometimes wonder if it's not time for us to revisit that section of the code, because who shows up down at City Hall to say, I wonder if they're having a meeting this week, when you could just look at the website. And so it's one of those, have we outgrown that provision? And then special meetings shall not be held without at least 24-hour notice, meeting and agenda notice, unless an emergency exists. So the requirement for special meetings is you absolutely have to have 24-hour notice unless there's an emergency. What is an emergency? It's loss of life or limb, or the risk of an immediate financial loss, or a likelihood that either of those things will occur if you fully comply with that 24-hour notice. When I think about that, that means to me that like the river is coming over the banks and crawling through the city, and if we don't do something, you know, immediately, we're in trouble. That's the sort of circumstance. Executive sessions, you can have a meeting that's an executive session only, but it still requires a 24-hour notice and agenda. If you have an executive session meeting only, it's important that you still observe the mechanics of the open meeting law, meaning you start an open session, you have your motion to go into executive session, your 2/3 roll call vote, and then when you're done, you come out of the executive session and then adjourn the meeting.